So welcome everyone. Good evening and very warm welcome uh, to this session. I'm Professor Dr. Ravi Kumar. We have still participants joining. I request the co-host along with me to let in the participants so that let me just concentrate on moderating. So I'm Dr. Ravi Kumar. I work as a associate professor and training and placement director in one of the and in a group of institutions yeah, which is located in Bangalore, Acharya Parkash institutions. And I'm thankful for IRAJ on behalf of Institute of Research and Journal Forum. I welcome you all for this special panel discussion and the topic that is National Conclave and panel discussion on shaping the future of family law. So today we have with us Dr. Dr. Amritpal Kaur, Dr. Anshi Joshi. Anshi Joshi is having some small technical problem. I think she's joining. Yeah, she joined. Dr. Anshi Joshi, Gazala, and we will be having also Dr. Amritpal Kaur, Dr. Chander Parkash, and Dr. Mohd Aqib would be joining as a panelist. And maybe Mohd Aqib's there is small technical error he was facing. He just texted saying that he will be joining. Maybe hope he will join soon. And let me give a very warm. I welcome all for this panel discussion. And let me just brief about the organization, Institute of Research and Journal Research Forum, which is a non-profit organization, which is basically meant for bridging the gap between the domains, and it is all the like students, professors, academicians, industrialists, and disseminate the knowledge to the public. So apart from this organizing, the organizations conducts seminars, webinars, expert talk, conferences, and various topics over here. And organization also have about multidisciplinary journals in the field of science, technology, engineering, management, and social sciences and all. And about around 8 to 10 journals are there, and around till now with the organization around a lack of papers have been published as a part of their in these journals, and also more than 3 to 4 lakhs people have been associated with this journal in the society, and the organization keeps on conducting these types of technical sessions and talks and conferences across the globe, not only in India alone, across the globe, and various international in forums also, physically and virtually. So let me come back for today's topic. That is, we all know that is National Conclave and panel discussion on shaping the future of family law. So we have with us to start with Dr. Amritpal Kaur, followed by Gazala Noor, and then Anisha, and then followed by also followed by Chander Prakash Singh will be joining, right, at the last. So let me just give a small brief introduction of Dr. Amritpal Kaur. Dr. Amritpal Kaur is an accomplished academician and legal expert. She has made significant contribution in the field of law through her research, teaching, and leadership roles. Known for her expertise in the various legal disciplines, she has strong focus on advancing legal education and contributing to the policy discussions. And we welcome Professor Amritpal Kaur ma'am for the session, and we will over to you, ma'am. Before that, we will, to make it lively and then to understand more, to know that you people are listening, right? I request all the participants to turn on their videos so we can, the panelists can also understand that. Yes, people are listening, or just for namesake of certificate, you're not here. And in the interest of learning and in the interest of understanding the subjects, we are here. So request participants to turn on their video, which is one of the formalities also to give the certificate. We can link it over there so that at least as a compulsion, you guys can turn on their video. So we can, have your smiling faces over here, and the panelists can also interact with you and can
Yeah.
discuss with you. Right. So over to you, ma'am.
Thank you so much,
Would you
Dr.
like to
Ravi.
share a presentation from your
So
end?
I would like to, there are certain points which I would like to discuss here. Am I
Okay.
audible?
Yes, ma'am. Yes, ma'am. You're audible. So we can
Okay.
just have a flow like this. First, initially, you can just give a overview and then followed by other speakers for other
Okay.
10 minutes. We will post that. We can have any queries or questions from the participants. And myself also some few doubts which I have can share across to you, the panelists, and then we will
Okay.
wind up the session with a vote of thanks. Let this be the
All
flow
right.
of the program.
Yeah.
So over to you, ma'am.
Thank you so much for wonderful introduction of mine. In fact, the topic of family law, the future of family law, shaping the future of family law, it's a very interesting topic. Now, in fact, we have seen that a lot of key developments have driven by the societal shifts are there, technological advancements in the modern era of 21st century, and there are certain changes in the legal norms. So, a comprehensive look will be taken up here in this talk related to the future of family law or various evolving systems in context of the legal system related to the family structures. So, when we are talking about the evolution of the family structures, we see that there is a recognition of diverse families. So, as family structures become more diverse, laws are evolving to recognize and support various forms. We have seen the latest development is the same sex marriages. Domestic partnerships are there, cohabitation, and blended families are there. So, non traditional parenting is another setup which we have seen in the modern era. We latest another uh, aspect which is there in continuation with the other family structures is the surrogacy, adoption, assisted reproductive technology, we call it ART, and other forms of parenting. Family law must address the rights of non biological and adoptive parents. So, changing marriage, divorce trends, declining marriage rates, increasing divorce rates, and rise in alternative relationships, such as cohabitation, they are shifting the focus of the modern family laws. So, when we are talking about the role of technology in family law, we have seen that in COVID-19 pandemic era, virtual hearings they were accelerated. So, the family law in the courts, they were all these due to these hearings. Certain, of course, there's certain questions were raised about the privacy and effectiveness in certain sensitive cases with respect to the virtual hearings. But that was the need of the hour at that point of time. So legal tech innovations are there, rise of the online legal platforms, AI-driven legal services. They have simplified the access to legal advice, document preparation, and mediation services. Digital evidence in disputes related to the family matters, the social media posts, the texts, digital footprints, they have increasingly becoming very, very critical in the family law disputes such as divorce and custody battles. So, children rights, custody innovations, we have seen as far as children rights are concerned, the best interest of the child, that was the standard. We have seen under Hindu Marriage and Adoption Act, the best interest of the child, under the maintenance laws, best interest of the child was taken into consideration because societies, they have become more child centric. So courts, they have also continued to prioritize the child's welfare and decision related to custody, visitation, and support. So shared parenting models are also there, wherein the growing shift is towards the parenting arrangements, wherein both the parents they have equal or near equal custody. So initially, the system was in 90s or in the old decisions, wherein we have noticed that the custody of the child was given to mother, but now the trend is changing. So here both parents they have equal custody rights. So it is reflecting the modern views on the gender roles in parenting. So child autonomy in custody cases in certain jurisdictions, children's preferences are also playing a larger role in the custody decisions. So the minors they have more say in their because they are their they can say their own words, they can use their own mind or they can speak their own mind in context of their own future. So the courts are listening to them when the child custody or the children rights are concerned. They are taken up in the courts. So mediation, collaborative laws are also very, very relevant these days. Alternate in dispute resolution, ADR mechanism, we have seen mediation, collaborative laws, they are gaining prominence as alternatives to the traditional litigation setup. So these methods are also seen as less adversarial and more family friendly. So when we see the future of ADR in terms of the family law cases, it's increasingly mandated or encouraged by the courts. It allows the family law cases to proceed to litigation. And of course, has a very positive impact. It is reducing the emotional and the financial toll on the families. So gender equality is another area which is taken into consideration in the courts in context of the family matters, wherein equal rights, as I've just mentioned, equal rights are given to the fathers. They have equal rights of child custody, the support matters. So the traditional stereotype is not taken into account. Spousal support reforms are also happening in the courts. So the modern family law is addressing gender equality, spousal support cases. They're focusing more on the fairness and reducing the gender bias in the alimony determinations also. So impact of social changes is, of course, there on various family law matters. Changing views on the marriage, divorce, because marriage rates, they are decreasing now. Divorce rates are increasing. I'm sorry I'm saying this, but the data, the statistics are saying this. Additionally, more couples are also choosing cohabitation over marriage. Family laws need to adapt to these social changes by offering protections to the unmarried couples, especially those who are in live-in relationships. LGBT rights are also gaining legal recognition. Family law matters or family laws or the courts, I believe, must continue to address the issues specific to them. Then domestic violence, child abuse protections are evolving to provide more comprehensive support to the victims. So in the future, I believe there may be stronger legal frameworks to address physiological changes, psychological abuses, or the coercive control, or the separation violence which is happening in the family cases. So globalization, cross-border family law is another area wherein international marriages, divorces, they have resulted in a lot of cross-border divorces are happening. It is also another challenge before the courts because enforcement of the orders, the issues related to jurisdiction and differing because cultural norms are different, cultural setups are different, laws are different at the international level. So the international custody disputes are also rising. The laws like we had Hague Convention. Of course, it's shaping the future of family law and handling the cross-border child abduction custody battles. So global adoption trend is another challenge. International adoption laws are changing. We have seen in India, Lakshmi Pandey's case, 1980, 80s, wherein the issue was related to the inter-country adoption. And this matter was taken up by the Honorable Supreme Court, wherein a lot of guidelines were also issued. So stricter regulations are the need of the hour to protect child's right, and we need to prevent the trafficking at the same time. So we have certain legal and social challenges are also happening, wherein the access to justice as family law becomes more complex, ensuring access to affordable legal services, especially for low-income families. That's a major concern before the courts. An emotional impact of the family law is another area which we can talk about that because we need to shape the future of the family law in this context as well. So cultural sensitivity, wherein the family law must adapt to the multicultural societies, respecting the religious and cultural differences in family arrangements, parenting, and divorce. Access to justice, I've just mentioned, legal aid is another area. ODR is another area which is an emerging area wherein online platforms are there that allow families to resolve legal disputes outside the courtrooms. Because the whole idea is to make the justice more affordable, convenient, and less intimidating alternative to traditional legal processes. Artificial intelligence is a new norm these days, and I believe there is a lot of future of legal practice in AI. So AI in legal search and document drafting, because AI-driven platforms are helping lawyers a lot in the legal search, document drafting, predicting case outcomes. So family law professionals, they need to focus on more complex and human-centered issues because AI it's doing its own job. So ethical considerations are another area wherein the technology needs to be integrated into family law, because at the same point of time there is another concern which is growing, that is about the privacy, data security, and the potential biases of the AI systems in these sensitive matters involving children and families. So I would like to conclude that we need to have more family centered laws, because the future of family law is moving towards a more inclusive, compassionate, and technologically advanced approach is something which we require at all levels, at the level of the lawyers or in the courtrooms at the time of giving the decisions. Because the whole objective of the laws, of course, are to minimize the conflicts and to ensure the fairness and prioritize the well-being of the children and families at the same point of time. So continuous adaptation is something which we need at this point of time. That is, family law professionals, legislators, society, they must continue to adapt to change the family dynamics, the cultural shifts, and the technological advancements in order to ensure that the family laws remain relevant and very, very fair to everyone. Thank you so much.
Take up the direction of this session from something very pivotal that Dr. Kaur mentioned. That is matrimonial dispute resolution. Ma'am mentioned about ADR methods, ODR, how these methods can be utilized to resolve matrimonial disputes in India. And I think while one of the biggest issues that Indian judiciary is facing right now is being plagued by the backlog of cases, if ADR is properly utilized and optimized, it could truly help us reduce that burden and actually come out with meaningful outcomes. There was this report by Vidhi Center for Legal Policy in 2016, in which there were 46,000 cases that year, till that year, which were referred to mediation. There was a particular time period taken. So in that time period, there were 46,000 cases referred to mediation. Out of those 46,000, more than 41,000 cases were matrimonial disputes, which roughly amounts to 90% and above. So such statistics, we can infer two very significant ideas from such statistics. A, there's a lot of burden regarding matrimonial disputes in our country. And if this was the figure in 2016, there certainly is going to be an upwards trend. As ma'am has said that the divorce rates have risen and matrimonial disputes are more and more these days. Secondly, there is also a trend for the judiciary and for the litigants to try and attempt ADR methods such as mediation or conciliation. Now, if I talk about matrimonial disputes, broadly 5 areas are covered in matrimonial disputes: marriage, divorce, guardianship, adoption, and maintenance. Now, marriage in each religion, each structure has its own ideas. In Hindu law, marriage is a sacrament. In Muslim law, it is a contract. So in a country like India, which is filled with diversity, so many religions, so many cultures, and the idea of unity in diversity is which brings us all together. India has so far been successfully integrating various laws and various cultures through the legal system that we have been following. Now, marriage is something that is not only a major milestone event in the life or any of the matrimonial activities, but it is also something which changes your status, which has also been one of the pivotal arguments in the case for arguing marriage equality for the queer community. That marriage is not just a right to relationship, or it is not just the right to stay together, to build a life together. It is also conferring a status, which is allowing you to move further into certain areas which are being created only by the fact that you are married. For example, the right of being the nominee in an insurance policy. So if I talk about heterosexual couples, right, as of now, in husband's insurance policy, the wife has the right to be a nominee and vice versa. However, if we are talking the same about a lesbian couple or a gay couple, where there are two male partners or two female partners, there are many, many such areas where such rights are not allowed. So there is a need of lot of developments, updations, and changes in the traditional structure of family law we have today, because the families are no more the same. We have mixed families, we have blended families, we have families with step parents, we have families where you have two dads or two moms. There are adoptive families. So these changes, because these changes are not just changes associated with the legal structure of that family, but there are also physical, psychological, mental, financial consequences, effects, implications attached to it. For instance, if there is a family where there are two mothers, as in a lesbian couple, and the child goes to school, and the child sees that, okay, this is a small child, 5, 6 year old, and the child sees that, oh, everyone has a father, everyone has a mother. The child is definitely going to go back to home and ask the mothers, oh, where is my dad? This is going to be a natural question of curiosity amongst the child. Why? Because for the child, it is something unusual. It is not something which is the norm. And it is going to be very difficult for the mothers in general parlance to reconcile that line of thought that it is normal to have two mothers, or is it normal to have two fathers, in contrast to having a standard family that we see in our textbooks: father, mother, brother, sister. So these are some of the areas where our family law does need updation. Now, if there is a family law, there are going to be disputes. And the disputes are rising every day because the society is changing so drastically, thanks to features like tech, AI, emerging expectations, new developments. Everything is contributing to the change in our social structure. And such change is also needed because initially, if we talk about the social structure in last 100 to 200 years, the society was fairly patriarchal. The society still is patriarchal, but that level of patriarchy was a different thing in itself. We had very, very horrifying practices. For example, sati, or there was a time when bigamy was allowed, polygamy was allowed. Some religions still permit these things. So therefore, these changes are important if we want to grow as a progressive society in general. And if we want to develop collectively and not just one or two of the sections or groups in the society want to develop. So there is this very beautiful quote said by Justice Sandra Day O'Connor, who was an Associate Justice of the Supreme Court of United States. She said that the courts of this country are not the places where the dispute resolution should begin. The courts should be the places where the dispute resolution ends. This shows that how important it is for us, both as lawyers and as litigants, because again, lawyers, we are at courts in our offices. When we come home, we are also parts of families, social circles, society, community. So as lawyers and as litigants, it is very important for us to realize that the very first step that we should take for resolving a dispute is communication. Communication is everything. Lots of cases have been before the court where the court has attempted a reconciliation, and that reconciliation has been successful merely because the parties were not communicating properly, or there was so much noise or distraction or distortion between the messages that were being passed that what they actually wanted was not at all being communicated to each other, and they were unable to come to a common ground. Similarly, Justice Warren Burger, who was the former Chief Justice of Supreme Court of United States, he has very rightly and very thoughtfully said that lawyers are the healers of human conflict. So in situations where there is a pendency of cases, especially with respect to matrimonial disputes, there are newer and newer issues emerging every day. As lawyers, I'm assuming that most of the people in the audience here are law students or belonging to the legal fraternity, since it's a panel on family law. As lawyers, our first moral, ethical responsibility is to heal the human conflict. I do understand that it is a profession and there are professional consequences attached to it. For example, the fees that we are charging. But our objective should be that the dispute should end in a satisfactory manner. When I say satisfaction, I do not mean just the material satisfaction, but also the psychological satisfaction. Now, as lawyers, when we receive such disputes, how do we approach them? So there is this concept called, I don't know if you've heard of it or not, but there is a concept called the conflict iceberg. We all have heard this phrase called the tip of the iceberg, right? So what is the tip of iceberg? When we are going through a sea and we see we're in the ocean and we see an iceberg. So the portion that is visible to us is only the tip. And it is the real iceberg, which is huge, which is massive and not visible to us from the naked eyes. It is actually submerged and we cannot see it unless we are closer. So that is how a conflict is. What you see above, what you see from the surface is only the layer that is visible to your naked eyes. Submerged under that hostility is actually emotions, personalities, expectations, egos, differential circumstances, all the different factors that are actually driving that dispute. Now, when we perceive all these factors, we can actually integrate ADR in resolving family law disputes in an efficient manner. If I talk about our statutory framework, that how it is supporting us in integrating ADR, there are lots of provisions in general in our statutory framework that provides us with recourse to ADR mechanisms, especially when today we also have our Mediation Act 2023. Now, there are certain family law statutes in India. The most utilized one is the Hindu Marriage Act, based on the demographic. So Section 23 of the Hindu Marriage Act, it imposes a duty on the courts to conduct and attempt reconciliation proceedings between the parties. But if the matrimonial dispute can settle with conciliation or mediation proceedings or by communication or with the help of a third neutral assistant, someone like a facilitator or a mediator or a conciliator, now a mediator mostly, as per the provisions of the Mediation Act, then that is the preferred way of resolving matrimonial disputes in India. A similar provision is there under the Special Marriage Act, Section 34. And there is an addendum to such provision that even in the case of a joint petition for divorce, such reconciliation proceedings are to be attempted. Thirdly, Family Courts Act. Family Courts Act Section 9 very clearly lays down that it is the duty of the court to encourage settlement and reconciliation between the parties. Now, wherever in a dispute, if the court sees that, okay, there is a reasonable possibility that this dispute can be resolved using methods like mediation or conciliation, or there's a chance that parties can talk this dispute out. Maybe they can communicate with each other, they can convey their concerns, grievances, maybe they can find a common ground, if not on all the issues that are there, but at least on one or two of the issues. Then it is the duty of the court to encourage such settlement, encourage utilizing the ADR mechanisms. Then Family Courts Act also goes one step ahead and empowers the court to involve NGOs, family welfare organizations, specialist organizations, wherever they feel that, okay, it is required or it could benefit the case of the parties in reaching a resolution. So this structure indicates that our legal framework is conducive towards ADR. It is repeatedly telling us to please take up ADR methods, please use ADR methods to resolve your disputes, and more so in family law, because we all have seen that family law disputes are not just about documents or legal questions or provisions. They are more so about the emotions of parties, circumstances of the parties, adjustment issues, parties' treatment of each other, cultural differences. All these factors come together and make a marriage difficult to survive, and therefore party take a recourse to a matrimonial relief. And in addition to our matrimonial statutes, there is also Civil Procedure Code, where we are having Section 89, which allows us to take recourse to ADR methods, whichever is suitable. There's also Order 32, which tells the courts, amongst, it's one of, I think it is Rule 3, it tells the court that please encourage settlement whenever a family law dispute has come before you. Now, although there is a recourse to all these methodologies in our law, the practical question still remains that our society is a fairly patriarchal society. There is still things like gender pay gap. There is still a huge chunk of society where women are stay-at-home mothers, stay-at-home wives, and husbands are the earning members. Then in a lot of cities, a lot of communities, the joint family structure is still prevalent. And the duties of women and duties of men in a marriage, in a family, in a community are different, differently lineated. So the question arises that how do we establish and how do we bring a parity, or how do we harmonize this structure with the legal system we have, with the fundamental rights we have that provide us for right to equality, that also provide us for special provisions, special legislations for women and children, that provide us to be on the same page, to have equal rights, to not discriminate among various sections of the society. So for such cases, for such situations, there are provisions like legal aid. We have Article 39A, right to legal aid. Then in the Legal Services Authorities Act as well, there's a provision that who are entitled to receive legal aid. So women, children, marginalized sections of the society, all these sections are entitled to receive legal aid. Afterwards, while we are taking these remedies, while we are going to resolve a family law dispute, it is very important for us to choose the right method. Which method is most important for us to resolve a family law dispute? With things like technology, with things like integration of AI, with faster communication channels, and the role of relatives, community, and everyone involved in each other's family business, it becomes slightly difficult to resolve a family dispute. So while we are resolving a family dispute, as Dr. Kaur very rightly said, the most taken approach is, if there are children in the mix, then you have to look for the best interest of the child. Any decision is to be taken while considering what is going to be the best interest of the child, how it is the life of the child which is going to be impacted, how you can go through this transition, because a divorce or a separation or an adoption, these are life-changing events. And the transition is not always very smooth. Even if someone is filing a joint petition for divorce, even then the transition is not going to be very easy. So it is important to identify all the circumstances that are surrounding our dispute. What is it that we want out of our dispute? What is our end game? What is the outcome that is desired for us? Is our dispute something which can be resolved by communication, by making minor adjustment, minor compromises, by making structural changes in our lifestyles? Or our dispute is so that our safety, security, bodily integrity is being threatened, that it has become impossible for us to continue with the relationship that is in place? Or the situation is so dire that involvement of medical professionals, police, lawyers has already been required. So that is a call that we have to take. Now, it is important to note here that a marriage can be dissolved and a resolution can be found through a reconciliation proceeding without going to the court. When I say without going to the court, I mean an amicable manner. But these reconciliation proceedings or ADR methods cannot be utilized to provide validity to a marriage which was already invalid in law. So the ADR methods are a facilitative process and therefore are to be used in the similar manner. Now it is on us as lawyers, as litigants, as social workers, as stakeholders of the society to firstly ensure that there is not a need for utilizing such methods, talking about both ADR and litigation methods here. How do we establish that? Firstly, we respect the rule of law. Secondly, we follow the family law. Thirdly, mutual respect and respect for dignity of everyone is a pivotal element for preserving relationships. If you want to preserve relationship, the very first step is mutual respect. and care for other person's thoughts, emotions, feelings. Now, this care is not at the expense of your own thoughts, emotions, and feelings, but that is where it comes upon finding a balance with the law and with the cultural differences, with the emotional differences, with the personality differences that are persisting amongst people. So, at the end, all I can say is that I hope we can utilize more and more ADR methods to resolve our matrimonial, family law, personal disputes. We communicate better, we respect each other better, and we do not find the need to be hostile to each other, especially in an integrated framework like that where the family law is applied. Thank you so much for your time, everyone. I would love to answer any questions at the end.
Good evening to all of you, to the chair and the chair other panelists also. It's been a pleasure here to be the part of IRAJ National Conclave, focusing particularly on the family law. My today's topic of discussion is particularly the impact of the terrorism as well as the national security measures on the family dynamics. We know terrorism is a greater threat, not to single individual, but to all the stakeholders, or each and every individual and every part, class, and caste of the society all over the world. I have completed my PhD area in this particular domain also, but now the often overlooked area when we talk about terrorism or a national security major is the impact on the family analysis. What is the actual impact? The areas which are actually facing the act of terrorism, or where national security measures are being taken, what is it is done. Yes, we have the international convention regarding the protection of the civilians in the war and all. What about the family dynamics? This is being overlooked in every aspect. I have concreted the things into 4 bullet points. The first impact which I found the most is the psychological impact. We can see due to such activities of the terrorism, and if terrorism is not there, any such activity which is provided particularly towards the national security measures, that create a fear and uncertainty within the family, and that uncertainty is creating the depression, that's the particular stress and every other aspects, which degrades the mental as well as the physical health also. The constant exposure, if we see, of the terrorist attacks or the possibility of the future ones, we cannot anticipate when and where an attack can happen. It creates the atmosphere of the fear as well as the anxiety. If you particularly focus on the children in the family dynamics, particularly such experience creates the level, increases the level of the insecurity within the children also, and which particular results in the behavioral changes, or we can say withdrawals, or we can say they are much more dependent upon the company of the family of the parents itself. They are unable to communicate with the other people in the society. Coming on the parents, the psychological impact is that they face a huge challenge. First of all, they every parent have their own emotional responsibilities, while due to these particular measures or the terrorist activities, they are trying to maintain and balance out the family situation, as well as reassuring the student, particular children also, that everything is safe. Children, they are being psychologically helped out with the parents, but what about those parents who is actually in the fear that yes, anything will happen at any moment? Recently, I few days back, 2-3 days back, I am teaching this particular subject of national security to the LLM students also. So there I was comparing the AFSPA laws, the Armed Forces Special Power Act of 1958, 83 and 1990. All the the provisions are 95% similar in nature, one of the student even asked me this question, sir, if the particular language, the provision has been added that any vessel, vehicle can be stopped, searched, they can enter into any place, keeping aside the provision of the CRPC of arrest how made, still they were shocked, the students were shocked to see what the legislatures has provided us. They can enter into any premises, check any almirah, open any drawer. These words have been actually used in particularly if you see the AFSPA. So now see a family, you can analyze if a family is particularly in a premises, and if the forces or any other people, they are entering into that and doing such activities. Now what is the impact on those particular child, and how a parent is able to control the situation as well as the child also. I have not watched, particularly I am from J&K itself, and I haven't watched the movie Article 370. And in the last 2 weeks, I have saw it. So the exact situation has been explained there. That what happened when attack is there, or the security forces are countering, everything. The family is there. One family member is killed before two child. Before the child, his mother, she was killed. What was the impact on that, but the psychological impact, the trauma can be seen in that particular phase of the child. Another thing is which I believe is the most important thing which we need to see is the due to such activities, the frequent thing which happen is a displacement as well as a separation also. During my PhD work, when I was doing the PhD, this was my core area, and this is one of the part of my questionnaire also, that whether have you seen during your life tenure in the particular valley or in the other area, because my core area was J&K itself. So what about the separation of that particular person from the family? It is, they are being, various reports are also there when the disappearances are there. So that disappearances due to any reason, killing the fundamental rights itself for those persons, they creates an impact on the family. It's, I would rather say it creates a direct impact, and which due to such activities, many families are affected and they are forced to displace from one place to another, focusing on their family dynamics so that they can give a secure environment to the family itself, to the children. Many families, they often flee from their homes. They lead to disintegration toward new traditions, new cultures, which creates another, a different impact on those families also. This is another question, that they are leaving behind their cultures, their area, and they are moving towards the new things. Now, another thing which due to these displacements, which is impacted on the parent itself, they are unable to make their children understand what is actually their culture, their history also. When we grew up, personally speaking, uh, the present home was around 2 hours away from the native place. My father used to take us, me and my brother, every weekend to the native place. This is my personal experience. So now today's situation is that when we are teaching the students and we are discussing the thing that what we actually done in our native place, we used to stay with our grandparents for 1 month or 1.5 months in the summer vacations. Now students are not doing that, the children are not doing that, because we are at so much displaced places. It is very difficult for the younger generation right now. Another thing is the lack of these particular physical proximities. These erodes the family bonds also, these separations, displacements. which causes, so many things. They are, disturbing the families, their dynamics, and they are providing long-term emotional scars. The prominent example is the migration of the Kashmiri Pandits. It's one of the prominent examples. Another point which is particularly dealing with the economic as well as the social consequences. If we see the aftermath of the national security measures as well as the terrorism, the act of terrorism, it is a huge crisis, and it involves a significant loss in the economy as well as a social bond and a social, the social, the arena which the families are being living. If we see in usually a family, in particularly if we talk about Hindu law, the head of the family known as the karta, who is the, we can say, breadwinner also. So that person is at the most peak pressure, and at the most that stage that he is, he's facing so many difficulty due to all these activities. And due to these activities, it could lead to destruction of property also, even displacement, which we discuss also right now. And all these things can also create the financial instability, which creates a pressure on that karta, that how it is a duty, a fundamental duty of the karta to manage all the affairs of the family, so that the family can live in peace. So that is another consequences. Another thing is, many family members, they are compelled, to perform various new duties due to all these particular things. In every family, every person has to play its role, every person has to do the contribution. But due to these things, due to this activity and the majors, the family, if the family dynamics is, disturbed, so a particular duty which a particular person, whether male or female, has to do, another person has to take that responsibility. That's also create another, a pressure, a psychological impact on that person, that I am doing everything, I have to bear everything, this and that. This creates, a new particular, now creating a new impact on the gender roles also. In many cases, if we see, men are known as a protector of the family. They are there to solve the queries, they are there to solve everything, they are there to protect the family. If you can see, if you can analyze, the things can be analyzed from the common examples itself. See in the market daily, it's a journal observation. Usually if any couple is going, it is the male who is holding the hand of their particular partner, who is keeping her safe. If you talk about a particular family where children are also there we can also see particularly that the usually a father is there, who is actually carrying the children, holding the hand, looking after everything. So now when such burdens due to these activities, these situations are there on a single person to ensure the safety of the family. Now you can imagine that that particular person itself is, not able to perform a duty which is in a culture or a society he is supposed to do. It is creating, I believe it is creating a much more difficult situation for a particular man itself. Such, these shifts, these displacements, these pressures, these psychological impacts, and they also give strain to the marital relationships as well as create tensions also. Many a times the man who is the breadwinner of the family, he is being forced by the family itself, that they are not safe, the financial instability is there. Lastly, if I talk about, which I conclude, is the, the particularly community and the extended family relations. It is another impact. If we see the terrorism and other security measures, they also affect the relationship with the extended families and the communities also. When a community is targeted due to these particular situations, it's it's create another impact. Families become isolated when they are being, they have to displace from one place to another. They are being isolated. Many a time the cultures are there. If you go to some village or a native place, it's a common culture there. They are having the homes all around in a circle or a semi, there, and a common veranda is there, a common place where children used to play. We also have saw that in our native place. Due to these particular situations, this type of a community, the communities, the extended family members are there. We can say the uncles, the aunts, they are being separated from one another. You can also observe these things, the minor, a minute detail. If you do any type of a simple family function in a city, you have to have some outsourced person to help you out. It's very rare that a extended family person, the other relations would come forward. But if you compare the same thing with the village community people, each community people, they will come, their own, that what they have to do actually. We have saw the marriages in our, places, na? They have installed all the, the tents and all. And behind every corner, if you see in the city or the hotel, behind every, the counter, you have a particular waiter or a chef or anything who will serve you the things. But if you talk about that particular place, a native place, there the local people, your own community people will, stand there till whole function is over. They will help you out in everything. Now, due to these particular act of terrorism and such measures, when the family has to move from one place to another, these family relations are being, targeted. So to conclude my whole, topic for today, my whole point is that terrorism, its impacts, the national security and the national security measures. Why I am putting more emphasis to the national security measures also, because my own study was on the critical evaluation of the anti-terrorism laws. I have actually, have the conversation with the families, the impacted families, as well as the security personals. And you guys won't believe that what is being shown to the people and what is actual reality. It is totally different. So to conclude today, terrorism as well as the national security concern, if we see, they have facets as well as various impact on the family dynamics. It could be a psychological impact. Economic consequences are also there, displacement, as well as changes in various role in the family also of a particular person, which also impacts the family bonds, the traditional structure in the family. While different, if we see the fabric of a family is what? Love and affection, which has to be maintained by each and every member of the family, and it is actually a duty of the state also to provide the security to each and every individual. If that is impacted, automatically a social structure, the particular structure of the family is also disturbed. That is all from my side.
For today's is the topic regarding the future of family law, which is the subject of ongoing debates, especially in terms of, you can say, the panel provision, or you can say the evolving the nature of family dynamics, which Anisha ma'am has already saying the family dynamics. So there are several trends and you can say the challenges which are likely to shape its future. Like there is a different types of you can say the challenges like discriminalization and the civil remedies. As Anisha Joshi ma'am has already saying that this is the topic, this is the law in which you can use the civil as well as the criminal nature also. So if there is a part of discriminalization and a civil remedies, definitely it trend towards the family violation, which I can say, and offering the civil remedies like in the really in the case law. And there is of course the gender neutrality in panel provision. Of course I will come to the point on that because that is the main point what I want to discuss. And of course there is a strengthening protection against the domestic violence. I think the domestic violence topic is the very vast topic which need the one more session to discuss on that. Okay, and there is of course, ma'am has already saying Dr. Kaur ma'am has already saying about that thing, the revisiting the marital rape laws. And of course, we need to discuss about all the laws regarding the matrimonial cases. And of course, the protection of child rights in family law. Dr. Kaur ma'am has already mentioned he shared the family arrangement, the parenting arrangement system must be there. And of course, the LGBT and the family rights, and there is a very typical and you can say the modern digitalization and a modern form of abuse in the family. Like now today's generation is the Gen Z generation, I must say that. So, because of the social networking, there is the modern form of abuse, like with the rise of the technology, new forms of digital abuse within the family context are emerging, such as cyber stalking. Every participant is here who might have stock on the and another profile, definitely, so that your profile will be best or the other profile will be best, and you are scrolling the reel, that is also considered as a cyber stalking, right? This is not about the increasing the views of the reels, but this must be considered as a cyber stalking, I must say. And of course, as Anisha ma'am has targeting about the UCC, and as she said that bigamy is still you said that bigamy is still considered in the other community. Yes, it is. And I don't want to consider on the UCC only because this is only there is a ongoing discussions in the Supreme Court. I am not touching that thing. So this will be considered in the another session because the time is lacking. We were not aware about this decision. This panel discussion will be considered more than 1 hour. So we are I'm just putting the few four lines. It's a request on the Ravi sir, can you please show my slides because my slides is not considered. Can you share the slides?
Yes, ma'am. Yes, ma'am. I'm
Yeah.
doing it. There is small technique. Yeah, I'm doing it.
So okay, as he's busy with the sharing the slides, so let us discuss about the in discussing the challenges, okay, surrounding maintenance. My main topic is the inadequate enforcement mechanism regarding the maintenance with the context of this panel law. It is important to focus on the legal, social, and gender dimensions that affect the enforcement and fairness of the maintenance order. The evolving family dynamics, social, economic condition, and the court interpretation significantly shape the panel discussions on the maintenance. So today I will definitely discuss the key challenging in enforcing maintenance under the provision, under the panel provision, or exploring how these issues impact vulnerable individuals. Okay, I'm saying here, I'm again repeating the word individual. I'm not saying whether it was a he or she will be the citizen of India or something else. I'm just saying the word individual, and the reforms needed to create a more equitable system. What kind of system? The legal system, of course. And can anyone know that the despite of the court order, there are over 40% of the maintenance order remain unpaid, leaving behind vulnerable families in a financial distress. As this is the first slide, everyone know that who can apply, as all the participants are well knowing person regarding the family law. This will be the first semester questions, and who can apply for the maintenance, what will be the court hearing and the maintenance order. This is the step by step which I will be discussed here. Can you please move to the second slide, Ravi sir? Yes, this is just one mechanism. I share here just a flow chart of the inadequate enforcement mechanism which is occurring by our legal system, but this was not happen practically, as there is a major challenge in maintenance cases is the lack of effective enforcement mechanism. Even after the court passes the maintenance order, but the receptant, like often women or a children, struggle to receive the timely and sufficient support due to the non-compliance by the paying party. Of course, this was the similar in between when you take the debt. जब आप किसी से कर्जा लेते हैं तो आप उसको क्यों, जब आपको पता होता है कि विद इन 1 month यू हैव टू पे द मनी बैक, सो वो नहीं देंगे. क्यों देंगे जब तक हम लोग अपना पैसा वापस नहीं लेंगे? दिस इज द सिमिलर दैट दे आर नॉन कंप्लायंस बाय द पेइंग पार्टी. वाई दे विल, जब तक हमें कोर्ट ऑर्डर देती भी है तब भी आगे वाली पार्टी चिल्ड्रन को या वुमेन को जो रिसिप्टेंट होते हैं उनको अपने टाइमली पेमेंट नहीं मिल पाती. And the panel provision which was discussed under the 125 CRPC, now it's a BNS, allow the imprisonment for failure to pay maintenance. That means it is in the loophole of the legal system that if they fail, then you have to go for a imprisonment for the failure. That means it's what already mentioned in our legal system. So this was the discussion part. If there is a failment, that means everybody is going to fail the maintenance, right? However, the panel consequences offer do not compel timely payment, as they do not address how the defaulter will pay once imprisonment. So there is a discussion part whether the imprisonment punishment does not create anything or not, right? So another thing which is most important point regarding the gender bias in maintenance laws, like there is a current legal framework assumes that woman is the primary recipient of maintenance. I don't understand why the women are always in a victim part, right? If I teach the student, I definitely inform my students that woman will be the considered is eligible to take the maintenance. Only woman is considered into the rape victim. Only woman is the primary recipient of the maintenance, reflecting the traditional gender roles. Although maintenance laws are designed to protect the economically weaker spouses, our law does not create any discrimination that he or she, but they are designed to protect the economically weaker spouses. The panel discourse lack clear guidelines for situation whether the husband or a male spouse might need maintenance. Court have been reluctant to fully embrace gender neutrality in such cases, but leaving the gap of the enforcement of the rights of male petitioners. Definitely, I will definitely ask this question. Should working women be eligible for maintenance? What should be the criteria for such cases? Is there any criteria? If there is a, can you please move to the second slide? I forget that I have made the slides also. I was just, next one. I have made, ma'am, please, Amritpal ma'am, if I am wrong, please correct me. The next slide, sir. I have made some, these are the different types of, next. Another next, sir. Yes, this is the, this one. This is the conflicting rule which I made. There must be the differences of the woman. If we talk about the criteria of the category, then I must say the ST woman, different criteria, SC woman, different criteria, OBC woman, different criteria. But I granted here, how can the law how can the law balance the economic independence of women with their right to support? I don't understand why there is the criteria putting on the independent woman if she is earning more than her husband, if she is eligible to seek the maintenance from her husband or not. There is always a question mark. That's why I make a cases in between, in which case the maintenance is granted, and in cases the maintenance is denied. And there is the conditional maintenance also. If the woman is uh, earning more than her husband, she is not entitled to take the maintenance from her husband. I don't understand why the maintenance part is still unclear definition. The reasonable maintenance, I must say, the reasonable maintenance is not only the kapda, roti kapda or makan. If my husband, if I was asking for the maintenance from my husband, I will never ever asking for the roti kapda and makan only. I will definitely say it is not including. This is the unclear definition which I supposed to say, the roti kapda and makan. Not only the roti kapda and makan, roti kapda and makan is considered from the monetary. So our the lack of you can say the lack of unclear definition of reasonable maintenance, the legal system does not put the monetary compensation. The word monetary compensation will definitely consider into a criminal part, not only the civil remedies. They say the maintenance, you have to give the maintenance, and they require roti kapda makan, food, shelter and clothes, which is already in the part of woman, definitely, right? So there is a challenges. The reasonable maintenance lacks the unclear definition in most of the laws, leading to the subjective interpretation by the courts. As what constitutes the reasonable vary depending upon the socio-economic status of the parties. So there is so many implementation occurs and the amendment occurs. Of course, change is the nature of law. If we say this line, so that means your law is not permanent, right? There must be change, there must be revived, there must be implement, there must be amended. So you need to focus only the one thing that you have to earn. You are very much clear with the maintenance. You are if you are seeking for the maintenance, what kind of maintenance you need, whether you want to go for earning the job, whether you go for the medical treatment, or you go for the if there is already mentioned in the bracket, if you see the act, there is a bracket inside including food, shelter, medical treatment and so on. But there are the other things, the monetary compensation. Who will decide the monetary compensation to the woman who is in need of the maintenance, whether for herself, whether for their children? As it was already mentioned in our act that the maintenance will be considered like 125 crpc, and there is another act 2007, the maintenance and welfare of parents and a senior citizen. Why there is a need of the another act, different act for the parents? Because senior citizen includes the parents, of course. And my thesis topic was the same, the 2007 act, because I learned a lot of things from the journey of my 4 years of PhD, that the maintenance part is still unclear definition into our law. So we should not explain that the medical statement, if our parents need the paracetamol, that will consider the 200 rupees, so only the 200 rupees will be seeking from our parents. No, I don't think so that the monetary compensation would not be sufficient for maintenance. So just it was taking the more time, so I will definitely continue these all the things. So by addressing these issues, we can work towards a more just, equitable legal system that upholds the rights and dignity of all individuals. And of course, thank you so much of participation in this important discussion. Thank you all participation and your valuable sides. We will definitely advocate for reform the balance, the rights and responsibility of all the parties. So it was a discussion only on the there is a lack of enforcement mechanism in the maintenance part, so we need to change it. So if there is any questions, voluntary questions, you can ask in any language, no hard and fast rule.